Welcome, brother. How are you?
I'm good, sir. How are you, sir? How is your health condition now?
I'm fine. I'm improving.
Okay, good to know that.
Mm. Just give me a minute, and thereafter we will get down to business and let
Sure, sir.
others join. Yeah. Let me submit, Mr. Amin Saab. Due to my health and medical advice, I am not in a position to observe fast in this holy month of Ramadan, for which I really apologize and I respect your sentiments and I seek your forgiveness.
No, it's okay, sir. It's okay, no problem. Even I have not also fasting.
No,
It's
it's very
okay.
important because we have to honor the sentiments of our friends hailing from religion of Islam. So it's
Yes,
important.
maybe. Yes, maybe.
Yeah. Anyway, today I propose a very, very important dimension of refugee protection at regional level. We have been deliberating refugee protection at regional level in the context of Europe or European mechanism for the protection of refugees. I also welcome you, Mr. Omjha. As I have said a few words in your absence to Mr. Aminur Rahman that today we are going to deliberate one of the most important dimension at regional level in the context of refugee protection. We are going to understand an important mechanism that has been designed by the European nation states, particularly the European Union. I welcome you all with a very warm good morning, and I propose and invite your questions, your inputs, your observations, your comments on common European asylum system. And this is the topic which I propose to deliberate today. My dear friends, it has always been claimed by the European nation states that Europe has always been regarded as an area of protection for people fleeing persecution, generalized violence of a massive scale, serious violations of human rights in their country of origin. It has always been the hallmark of the Council of Europe Charter that Europe should always be regarded, Europe should always be branded as an area of civil liberties, as an area of freedom, fundamental human freedom. Taking into account European values, as I have already submitted those values for your perusal, for your consideration, in that very context, it becomes necessary to develop and to understand, my dear friends, this kind of a mechanism which has been proposed by the collective wisdom of the European nation states in the form of the common European asylum system. My dear friend, asylum is a fundamental right and an international obligation of the nation states, as it has been recognized in the 1951 UN Convention relating to the status of refugees with its additional protocol of 1967. It's very, very important. In European Union, and that is an area of open borders and freedom of movement, member nation states share the same fundamental values and joint approach, a comprehensive approach, a collective approach, a holistic approach to guarantee high standards of protection for refugees at regional level in Europe. My dear friends, European Union nation states have a shared responsibility to welcome asylum seekers in a dignified, humanitarian-oriented manner, while ensuring that they are treated fairly and their case is examined following standards, international obligations with uniformity, unanimity, and ubiquity. This ensures that no matter where an applicant applies, the outcome will be similar. Outcome will be identical. Therefore, the procedures must be fair, effective, and humanitarian throughout the European Union. This is one of the most important deliberation that has come out. And these kinds of what you call elements of fair procedure, my dear friends, must under all circumstances be imperial. If these circumstances of procedures have been addressing in a manner that is considered to be impervious to abuse. However, my dear friends, asylum flows are of constant, nor they are evenly distributed across the European Union. For example, my dear friends, they have varied from country to country, year to year. But this is very, very important to understand in this background, the idea of common European asylum system. Having said all these, or having submitted all these dimensions, since 1999, European Union has founded a common European asylum system, in abbreviation that is known as Ceas, CEAS. In 2020, my dear friends, the European Commission proposed to reform the system through a holistic approach to migration and asylum policy based on three main pillars. These pillars constitute one of the most important understandings, my dear friends. Number one is efficient asylum and return procedures. Number two is solidarity and fair share of responsibility. That has also been contemplated and envisioned in the global compacts on refugees. And number three is strengthened partnerships with third countries. Number one is efficient asylum and return procedures. Number two is solidarity. And number three is strengthened partnerships. Therefore, my dear friends, if you take into account the legislation and institutional support, you will find that the common European asylum system sets out common standards and cooperation to ensure that asylum seekers are treated equally in an open and fair system whenever they apply or they are found. The system, I mean, the common European asylum system is governed by the 5 important legislative instruments. And there is only one agency. There have been, my dear friends, asylum procedures directives. Asylum procedure directives, my dear friends, basically addresses at setting out the conditions for the fair, agile, and quality asylum decisions. Asylum system, therefore, or asylum seekers with special needs, with specific needs or particular what we call treatment to receive the necessary support to explain their claim and particular protection of unaccompanied minors and victims of the torture that has also been ensured in Asylum Procedures Directive. Another important directive is known as the Reception Conditions Directive. Reception Conditions Directives, my dear friends, ensures that the common standards for reception conditions such as housing, food, clothing, and access to healthcare, education facilities, livelihood opportunities, I mean employment opportunities under certain important specific conditions are provided for asylum seekers across the European Union to ensure a dignified standard of living, or to eke out a dignified standard of living in pursuance to, my dear friends, with the Charter or European Charter of Fundamental Rights. Because whatever the treatment we have been talking in the regional context at European level, all kinds of treatments to refugees, all kinds of rights of refugees, all kinds of promotions, propagation, and protection of refugee rights must be in consonance with other important specific human rights, what we call conventions, which have been over the years, particularly since 1951 or 1950, have been adopted under the auspices of the European Council, must also be preserved, implemented. And these directives, whether it is the Asylum Procedures Directive, whether it is the Reception Conditions Directive, or other directives which I am coming to deliberate, must also be in consonance with those very, international standards at regional level. Another important directive that comes to my mind is the Qualification Directive. And the Qualification Directive, my dear friends, enhances the protection of asylum seekers and further what we call clarifies the grounds for granting international protection, and therefore making asylum what we call decisions more robust, pragmatic, and plausible. It also provides, my dear friends, access to rights and integration measures for beneficiaries of international protection in Europe. There is another important measure, and that is the Dublin Regulation. My dear friends, Dublin Regulation accelerates the protection of asylum seekers. That really increases the threshold of what we call of protection of asylum seekers during the process of establishing the state responsible for examining the application, and clarifies further, my dear friends, the rules governing the relations between states. Dublin Regulation further clarifies, my dear friends, or further what we call creates a system to detect, a system to identify, a system to detect early problems in national asylum, to reception what we call systems, and addresses their root causes before they develop into fully or In other words, let me put it like this. Dublin regulation is the only what you call, regulation of distinction, my dear friends, that really what you call, causes before any kind of a legislation, any kind of, measures are taken at regional level by the respective European nation states governments. And before it, develops into a full-fledged what you call, crisis. So that crisis is always what you call, addressed in its infancy. Another important, system which comes to my mind is that is the Eurodoc regulation. My dear friends, Eurodoc regulations supports the determination of the member states' responsibility, or member states who are considered to be responsible under the Dublin what you call, regulation, and allows law enforcement authorities access to the EU database of the fingerprints of asylum seekers under strictly limited circumstances in order to prevent, detect, or investigate the most serious what you call, crimes such as murder and terrorism within the what you call, four walls of Europe. Another important agency is also, there, and that is the European Union Agency for Asylum. My dear friends, European Union Agency for Asylum generally contributes to improving the functioning and implementation of the common European asylum system, and it further what you call, provides operational and technical assistance to member states in the assessment of applications for international protection of the rights of refugees across the Europe. That is the main and fundamental function. But it requires, my dear friends, another important what you call deliberation, and that deliberation is relating to reforms, but I will what you call address that particular idea subsequently. We have to understand at this stage, my dear friends, what has been the objectives of common European asylum policy or asylum system. My dear friends, the fundamental objectives of the European Union to develop a common policy on asylum, or to develop a subsidiary protection or temporary protection with a view to offering appropriate status to all non-European or more non-European Union what you call nationals or citizens who need international protection. It further ensures, my dear friends, that the principle of non-refoulement under all circumstances must be observed. This policy must be consistent with the Geneva Convention relating to the status of refugees of 1951, with its additional protocol of 1967. It is important, my dear friends, that the European Charter of Fundamental Human Freedoms or Human Rights provides a definition of the term asylum or refugee. But it refers explicitly to the Geneva Conventions and its additional protocol. And therefore, it becomes very, very important, my dear friends, to understand the achievements of 1951 Convention and what exactly has been the evolution of common European asylum system. If you take into account, my dear friends, under the 1993 Treaty of Maastricht, that has previously ensured the intergovernmental cooperation in Europe on asylum, that was ultimately brought into the EU's institutional framework. And that has really worked as a foundation to develop European Union institutional framework for the protection of refugees within the European nation states. As the main actor, the Council of Europe was to involve the European Commission in its work and inform European Parliament about its asylum initiatives. The European Court of Justice, or you may call it the Court of Justice of the European Union, had no jurisdiction on asylum matters. But the judicial framework that has been ensured under the EU law, and that is the European Union what you call law, that ultimately influenced the decision making procedures which are generally taken under this common European asylum system. In 1999, the Treaty of Amsterdam, my dear friends, granted European Union institutions new powers to draw upon legislation in the areas of asylum, while using a particular institutional mechanism, a 5-year transitional period with a shared right of initiative between the Commission and the member states or European member states, and decision by unanimity in the European Council after what we call consultation with European what we call Parliament and the Court of Justice of the European Union, which is popularly known as in abbreviated form CJEU. And that has also gained jurisdiction in specific instances or in specific situations. Treaty of Amsterdam is of a vital importance, my dear friends, that also provided after this initial 5 years phase, European Council could decide that the normal co-decision procedure should apply and that it should henceforth adopt its decision by qualified majority. European Council, therefore, my dear friends, took a decision to that effect at the end of particularly of the 2004, and the co-decision procedure, now known as the ordinary legislative procedure, has applied since 2005. With the adoption of the Tampere program in October 1999, the European Council decided, my dear friends, that the common European asylum system should be implemented in 2 important phases. Phases like, number 1, the adoption of the common minimum standards in the short term should lead a common procedure and a uniform status for those who are granted asylum valid throughout the European Union in the longer term. This ultimately, my dear friends, resulted in the first phase of the common European asylum system, and that starts from 1994 and goes up to 2004. And in this particular phase, my dear friends, I mean from 1999 up to 2004, that ultimately resulted in the establishment of the criteria and mechanisms for determining the member states responsible for examining asylum applications. And it ultimately, replaced the international intergovernmental, what we call, 1990 Dublin Convention, including the European Asylum, database, which is popularly known as the Eurodac. And Eurodac for storing and comparing what we call, fingerprints, data. And it is further what we call, strengthened in the subsequent years. And we have been what we call, witnessing the intervention of the artificial intelligence in this particular, connection. Because it also defined European common asylum system as common minimum standards to which member states were to adhere in connection with the reception of asylum seekers, determined qualification criteria for international what we call protection, and the nature of protection granted, and established what we call procedures for granting and withdrawing refugee status. It does not stop here, my dear friends. It goes further, and it talks of further legislation covered temporary protection in the event of mass influx, and this is what we have been witnessing in cases of what we call of since 2011, from the month of March, the influx of Syrian refugees in Europe. Now we are witnessing another group of mass influx, and that is the Ukrainian refugees. My dear friends, in the month of November in 2004, Hague program called for the second phase instruments. Second phase instruments and the measures to be adopted by the end of 2010, highlighting the EU's ambition to go beyond minimum standards and develop a single asylum procedure comprising common guarantees and a uniform status for those granted protection. In the year 2008, my dear friends, European Pact on Immigration Asylum, and this deadline was postponed to 12. That was, ultimately came into existence. But it becomes very, very, very important, my dear friends. Another important treaty mechanism, and that treaty is popularly known as the Treaty of Lisbon. Treaty of Lisbon, my dear friends, came into existence, came into force in the month of December in 2009. And this particular, Treaty of Lisbon ultimately changed the situation by transforming the measures of asylum from establishing minimum standards into creating a common system comprising a uniform status and uniform procedures. And that has ultimately become the hallmark or the USP, I should say, of the common European asylum system. Treaty of Lisbon has contemplated a uniform status of asylum. Treaty of Lisbon, my dear friend, has also envisioned a uniform status of subsidiary protection. Treaty of Lisbon has also contemplated, my dear friends, a common system of temporary protection. Treaty of Lisbon further advocated a common procedure for the granting and withdrawing of uniform system or uniform asylum or subsidiary protection status. Treaty of Lisbon, my dear friends, further envisioned, I should say, a criterion mechanism for determining which member states is responsible for considering an application of the asylum seeker for the purposes of a determination or declaring refugee status or attributing or granting refugee status. It has also, my dear friends, the Treaty of Lisbon also stated standards concerning reception conditions. Treaty of Lisbon has also encapsulated partnerships, my dear friends, and cooperation with the non-European Union nation states. Therefore, we can say, my dear friends, that the Treaty of Lisbon was adopted, or since the adoption of the Treaty of Lisbon, Article 80 of the, earlier, treaties, particularly the Treaty of what we call of the Maastricht and treaty, particularly of the Treaty of, Maastricht, has also explicitly provided for the principle of, solidarity and fair shared responsibility or shared responsibility, and that has also been appropriated under the New York Declaration at international level, and that has also been translated into action in 2018 in the form of the Global Compact on Refugees. My dear friends, the European Union measures concerning asylum should, if necessary, contain, my dear friends, appropriate measures to ensure this fundamental principle, and it must be followed. The Treaty of Lisbon also significantly altered the decision-making procedure on asylum matters by making court decision the standard procedure. Additionally, my dear friends, the arrangements for judicial oversight by the Court of Justice of the European Union have been improved very, very significantly. Preliminary rulings, if you take into account, may now be sought by any court in member states rather than just national courts of the final instance, as was previously been the case. This has ultimately enabled the Court of Justice of the European Union to develop a larger body of case law in the field of what we call of asylum in the regional context. Another, after Tampere program, after Hague programs, we must take into account another important program that has also been designed by the member states under the auspices of the European Union, and that is the Stockholm Program. And the Stockholm Program, adopted by the European Council on 10th of December in 2009, for the period that it starts from 2010 and goes up to 2014. And in this particular period, it has been reaffirmed that the objective of establishing a common area of protection and solidarity based on common asylum procedure and a uniform status for those granted international protection. And it has also further, stressed particularly the need to promote effective solidarity with those member states facing particular pressures and what kind of a role, particularly the central role to be played by the new European Asylum Support Office that has been what you call established under the what you call Stockholm Program. However, although European Commission had presented its proposals for the second phase of the common European asylum system as early as 2008 and 2009. During this particular period of 1 year, my dear friends, or more than a year, what we have witnessed that the negotiations have progressed gradually and consistent thereof. The second phase of the common European asylum system was adopted following the entry into force the Treaty of Lisbon, and that too with a change of emphasis from minimum standards to a common asylum procedure on the basis of a uniform protection status in European Union. Therefore, it becomes necessary, as I have already submitted for your consideration, for your perusal, my dear friends, that there are main current legal instruments and current reform efforts. And these efforts, under all circumstances, must be taken into consideration. My dear friends, with the exceptions of the reformed Qualification Directive, which entered into force in July 2000, I think not July, it was January, I think. Yes, January 2012. The other what you call reformed legislative acts only entered into force in July, in the next what you call year, in the year 2013, in the month of July. We have been witnessing the reception of the Eurodac regulation, the Dublin third regulation, the reception conditions directive, and the asylum procedure directive, which meant that their delayed transportation or their what you call transposition or their juxtaposition in the middle of July 2015 fell at the peak of the migration crisis. In July 2014, the European Council drew up the strategic guidelines for legislative and operational planning in the area of freedom, in the area of security, and in the area of what you call justice. You can very well understand these are the attributes which are generally identified with entire what you call area that was initially agreed upon in the within the rubrics of Schengen Treaty of 1985. My dear friends, Commission communications are equally important and building on the progress achieved by the Stockholm Program. These guidelines, I'm talking of the strategic guidelines for legislative and operational planning. Therefore, these guidelines generally emphasize that the full transposition and juxtapositions effective implementation of the common European asylum system is an absolute priority of the European nation states. In this particular conspectus, the migratory pressure that has started from 2014, in May, in the month of May 2015, the Commission issued the European Agenda on Migration. And my dear friends, the paragraphs of this agenda on migration or European agenda of migration, the paragraph number 4 and its sub paragraphs, which proposed several measures to address this particular pressure, including hotspot approach that was shared between the European what we call Asylum Support Office, and that is the European Border and Coast Guard Agency, that was formerly known as, and it was very much popular in its abbreviated form as a Frontex, as it has been known earlier, and the European Union Agency for Law Enforcement, what we call cooperation, which is today known as the Europol. which involves, my dear friends, working on the ground with frontline, member states of the European Union to swiftly identify, register, and what we call, fingerprint common migrants. Therefore, the hotspot approach was also meant to contribute to the implementation of the emergency relocation mechanisms for a total of what we call of the more than 1,60,000 people in need of international, protection at that point of a time. Subsequently, my dear friends, the mechanisms were proposed by the Commission to assist Italy and Greece and adopted by the Council on 14th and 22nd of September in 2016 after the conclusion of a treaty between what we call, European Union on one side, on the other side, it was the, country like, Turkey. My dear friends, the European Council decision was later maintained in the court, and that is the Court of Justice of the European Union judgment of 6 September 2017. And we have also, witnessed in this particular, connection, the relocation. And relocation meant, my dear friends, as a mechanism, I should say, my dear friends, that is exclusively based on the what we call standards which have been agreed in this particular mechanism that is known as the European Common or Common European Asylum System. So that has to be taken into consideration. My dear friends, if you take into account another important what you call dimension of the relocation, you will find that the relocation rates have been lower than expected, and relocations have also been implemented very, very slowly. European agenda on migration also, my dear friends, sets out further steps towards a reform of the common European asylum system, which were presented in two important packages of the legislative proposals in May and July 2016. And that was, subsequently deliberated between the European Parliament and the European Council throughout the, legislative term that ultimately, ended recently, I think, in 2019. However, no legislative acts were adopted due to the files being blocked in the European Council or other specific, files being put on hold due to the blockages on connected what we call, files. This set of, legislative initiatives intended to improve inter alia the common European asylum system by proposing directly applicable what we call, regulations instead of directives, particularly or as a what we call, exception for reception, conditions which would continue to be covered by a directive that would still require implementation within the what we call municipal legal system. And my dear friends, if you take into account what kind of measures have been what we call taken under this grand what we call vision that is known as the European Agenda on Migration. Number one, under this agenda, European Agenda on Migration, measures to simplify, clarify, and shorten asylum procedures, while ensuring common guarantees for asylum seekers, to ensure stricter rules to combat abuse, including a common list of the safe countries of origin, which was originally proposed as a separate regulation. Parliament's what we call Committee on Civil Liberties, Justice and Home Affairs adopted this particular report. That was the first important measure. The another important dimensions was relating to the who can qualify for international protection. For that, we have to understand the entire in its entirety the Qualification Directive or proposed what we call Qualification Directive. The main being to achieve greater what we call convergence of recognition rates and forms of what we call protection, including more restrictive provisions, sanctioning applications, or sanctioning what we call, granting applicants what we call, claims. Secondary movements are equally important, and compulsory status reviews, even for recognized refugees, have to be taken into consideration. My dear friends, the directive of the 2013 of the European Parliament and the Council of Europe of 2013, whereunder we find the adumbration of standards for the reception of applicants for international protection, which is popularly known as the Reception Conditions Directive in the reformed what we call form, or the recast what we call form, replace the first phase council directives on minimum standards for the reception of asylum seekers in Europe. The recast what we call directive, therefore, my dear friends, aims at ensuring what we call dignified and more what we call harmonized standards for reception conditions like access to housing, food, clothing, healthcare, including medical what we call facilities, as well as what we call mental health has also been what we call included in the form of the psychological care, and then the education for minors and access to what we call employment opportunities under what we call specific conditions. So therefore, that becomes very, very important, and that should also be taken into consideration. Again, it has also been, when we are talking of the European agenda on migration, it must also be taken into consideration that it has also advocated the idea of reform of the Dublin Regulation, which lays down criteria for determining the member states, or the member states in nation, or rather I should say member countries, responsible for examining an application for the international protection. The proposal preserves the current criteria in the Dublin system while supplementing them with a corrective allocation mechanisms to relieve member nation states that are under disproportionate pressure. Therefore, my dear friends, in the context of what we call the Eurodoc asylum fingerprints database, that is another important step, a revision of the Eurodoc asylum fingerprints database, extending it to cover personal data on non-European Union nationals who have not what we call applied for international protection and have been found to be staying irregularly in the territories of the European Union, and further allowing law enforcement to access to that very database to collect and to investigate the fingerprinting of the children from the age of 6 to facilitate tracking and family reunification what we call exercises. Therefore, European Asylum Support Office also started what we call transforming from a supporting EU agency into a full-fledged EU agency for asylum, which would be responsible for facilitating the functioning of the common European asylum system, ensuring convergence in the assessment of the asylum applications across the European Union, and monitoring the operational and technical application of the European Union law, including, my dear friends, assisting European member states with the training of the national experts. European Parliament has also adopted its report on the proposal of December 2016, and in the middle of what we call of June 2017, a broad provisional agreement with the European Council was also reached, and therefore on 12th of September in 2018, while the June 2017 17 provisional agreement was still on hold, the European Commission, my dear friends, adopted an amended proposal for a regulation of the European Union, which is regulation, thereunder defined, and at the same time it has also what it was to clarify certain operational tasks of the European Union asylum what we call cooperation, and aiming to align certain important provisions of common European asylum system. My dear friends, in the subsequent years, we also find, in the context of what we call of Europe, a union resettlement framework, a union resettlement what we call framework, which would provide, my dear friends, particularly for common European rules on the admission of the non-European nationals. And these nationals are direly in need of the international protection, including financial support for member states, what we call efforts in the context of the resettlement, what we call endeavors. Therefore, union resettlement framework complementing the current ad hoc multilateral and national resettlement programs. Therefore, this kind of approach has also been what we call adopted. However, as the committee of the permanent representatives of the government of the member states to the European Union did not formally endorse it. Negotiations at the technical level continued, and European Parliament subsequently informally indicated that in principle it stands by the provisional agreement arrived in the June 2018 trilateral what you call negotiations. The Council, European Council, my dear friends, continues to deal with its legislative file following the package what you call or the holistic approach. There have been another important development in 2020. The European Commission issued the new pact on migration and asylum in an attempt to give a fresh what you call impetus to installed common European asylum system reform. This particular pact, my dear friends, aims to strike a new balance between responsibility and solidarity. The European Commission proposes to integrate the asylum procedure into overall migration management, linking it with the pre-screening and return. It has also been proposed, my dear friends, in this particular new pact on migration and asylum by amending its 2016 proposal for an asylum procedure regulation, a broader, or rather I should say, a very comprehensive deliberations have also been taken into consideration, and this has ultimately what we call resulted in the adoption of this particular amended proposal for an asylum procedure regulation. My dear friends, a pre-entry screening process which was, or which should, I should say, which should be applicable to all non-EU nationals who are present at the external borders without fulfilling the entry conditions, or after, I should say, disembarkation following a search and rescue operations. That was also what we call one of the proposals for a pre-entry screening regulation. So such kind of drastic proposals have been what we call mooted, have been proposed for asylum and migration management, and ultimately we find that today the European or the common European asylum system has been further what we call strengthened, and that has been taking into consideration the entire what we call reception of humanity, or particularly the people who have been fleeing persecution from their country of origin, and they are being what we call extended lot of what we call thresholds of protection, humanitarian aid, and a range of rights have also been contemplated for their understanding. Therefore, that brings me to another important dimensions, and that is what should be done from here. Oh, I'm sorry, what happened to my camera? Having this entire canvas of understanding of the regarding the common European asylum system, the most fundamental what we call question that really impels me to ponder over what is more. My dear friends, if I take you from this much of development, this much of understanding, it becomes necessary to understand the institutional framework that has been over the years strengthened and reformed. Therefore, we have to understand the European Commission and its further proposals. European Commission proposes to build on the progress already made on the remaining files. And European Parliament and the European Council are encouraged to progress as swiftly as possible. Particularly on the issue of the Qualification Regulation, Reception Conditions Directive, European Union Resettlement Framework, And finally, my dear friends, the European Commission. European Commission, in its recommendations of the legal pathways to protection, refugee protection, particularly in European Union, recommends, my dear friends, that the member states implement in 2021 unfulfilled, promises, pledges for resettlement from 2020, and invites the member states to introduce and make more use of common pathways in this particular connection for humanitarian admissions, such as the family reunification and community or private what we call sponsorship scheme, as well as complementary pathways linked to education and work. There are certain important terminologies, my dear friends. Family reunification has always been the hallmark of any kind of a reception, whether it is United States of America, whether it is Canada, or some other what we call geopolitical entities, so far the rights of refugees are concerned. But at a regional context, particularly in the context of Europe, what we find is that the sponsorship schemes, private sponsorship schemes, constitute a very, very innovative what we call addition. What we have been witnessing, and it was particularly identified in the case of Syrian refugees, the Syrian exodus of refugees, that ultimately result in the mass influx in the European Union or the European Union nation states, and that was started in the month of March in 2011. It has been initially what we call thought, and voluntarily and spontaneously this particular idea came into existence when people of Hungary, the people of what we call of Germany, and people of some other what we call European nation states have started in their private capacity as a family. They started extending receptions to the fleeing refugees, fleeing from the persecution in their country of origin, and it was the Syrian refugees. Then the idea of private sponsorship or the private sponsorship schemes came into existence, and it has been regarded, my dear friends, in global compact on refugees as a complementary pathways, and that has been linked to what we call healthcare, education, and what we call employment opportunities, as per 1951 UN Convention relating to the status of refugees with its additional protocol of 1967. So this idea of voluntarism came into existence, and we must what we call try to implement this particular idea within the rubrics or within the four walls of Europe. That constitute a very, very important innovation. But at the same time, my dear friends, we have to take into account the external dimensions as well. Because if you take into account what has been adopted in 2011 by the European Commission, the global approach to migration and mobility is the overarching framework of the European Union external migration and asylum policy. If you take into account this particular proposal of the European Commission, that is the global approach to migration and mobility, my dear friends, it defines how the European Union conducts its policy dialogues and cooperation with non-EU countries. And that is exclusively founded on clearly defined priorities. That has to be taken into consideration, my dear friends. And we must what we call, try to understand that what has been the, work in this particular, connection, because it is embedded in the European Union's overall external action and includes development, what we call cooperation. Its main objectives are to better organize legal migration, to prevent and combat illegal migration, and to maximize the development impact of the migration and mobility, and to what we call enhance, to advocate international humanitarian protection of what we call of refugees. This is very, very important, my dear friends, because it ensures further, if you take into account what exactly have been the developments in other parts of what we call of or other parts within the European Union, then you will appreciate my line of inquiry as well. Because what we have been witnessing, that European Council, and it's a very, very important development, my dear friends. European Council and the Republic of Turkey arrived at an agreement in the month of March in 2016. And this is popularly known as the EU-Turkey Treaty. And this was agreement directed at reducing the influx of irregular migrants into Europe via Turkey. My dear friends, as per the, or in accordance with the EU-Turkey statement, all new irregular migrants and asylum seekers coming from Turkey on the Greek what you call islands and whose applications for asylum have been declared inadmissible should be returned to Turkey. At the same time, my dear friends, for each Syrian returned to Turkey, another Syrian should be resettled in the European Union territories. And in exchange for further visa liberalization for Turkish what you call citizens and the payment of the euros in the form of what you call the 6 billion euros under the facility for refugees in Turkey. So in some private quarters, EU-Turkey agreement has also been branded informally as a money minting machine that has been established by the political wisdom of Turkey. It has been one of the most important allegations against this particular agreement, and that is popularly known as the EU-Turkey Treaty of 2016. Therefore, my dear friends, according to the European Commission's last progress report on the implementation of the European Agenda on Migration, and that was released, my dear friends, in 2019, if I am correct, the statement has continued to play a key role in ensuring that the challenge of migration in the Eastern Mediterranean is addressed effectively. However, the report stresses that Turkey is today facing accelerating migration pressure, highly increasing what we call migration pressure as instability in the wider region continues, and that the European Union assistance provides vital support to people in need via euros 6 billion facility for returnees or for refugees in Turkey. In the month of February, my dear friends, at the initial stage of the 2020, Turkey threatened to suspend the statement or suspend this particular understanding, leading to knock-on effect in Greece, which suspended the right to asylum and blocked large numbers of migrants at its borders. Additionally speaking, my dear friends, and it has also been what you call reported that there has been a lot of pushbacks in the agency. In March 22, again in the subsequent month, that is the March what we call 2020, Turkey suspended the readmission of returnees from the Greek islands because of the pandemic, and the European Union is currently trying to persuade Turkey to resume readmission at the highest what we call political level. But there has not been a very proactive political will on the part of Turkey, but some kind of a relaxation has been there. And one of the most important key initiatives, my dear friends, presented in the new pact on migration and asylum was the promotion of the tailor-made and mutually beneficial partnerships with non-EU what we call nation states in the area of what we call of migration. This has resulted in the form of what we call EU-Turkey statement might serve as a blueprint for future European Union cooperation agreements with North African nation states. Although the compatibility of the measures under the what we call EU-Turkey statement with international and European Union refugee law and human rights standards remains questionable. On a global level, on the other hand, my dear friends, in the month of September in 2016, United Nations General Assembly unanimously adopted the New York Declaration for Refugees and Migrants. I have already, submitted what kind of a result and what kind of a framework this particular, declaration has ultimately what you call, come out with. And it is a landmark, a political, declaration, I should say, my dear friends. And that was completely what you call, addressing at improving how the international community responds to the large scale movements of refugees and migrants and to protracted refugee situations. My dear friends, I have submitted time and again. And again, I am submitting that 2016 New York Declaration constitute a very, very vital political milestone in the history of what we call of refugee protection. It was this declaration of the 2016 that was adopted during the presidency of the Barack Obama that ultimately realized and recognized, rather, I should say, the political characteristics of the refugee problem. It was this declaration that for the first time we have, collectively, we, the people of the world, collectively recognized that the New York Declaration established the political character of the refugee crisis. In earlier incarnation, every national government avoided to recognize the political characteristics of the refugee crisis. Whether it is the United Nations High Commissioner for Refugees, whether it was some other important agencies indulging and dabbling in the protection of refugees, every agency has talked of the non-political character of their organization. They have talked of the non-political what we call character of the refugee problem. They always talked of the humanitarian characteristics of the refugee crisis, but they never recognized that this crisis basically owes its origins in the politics or political hierarchy in the country of origin. It is basically a political problem. Considerably, significantly, refugee crisis is the result of the political turmoil in various geopolitical entities. What is happening? The latest example I can substantiate my line of argument by resorting to the emergence of the Ukrainian refugees in the neighboring what we call countries. It is basically a result of what we call of the conflict, war of an international character. War is war. You can attribute any name to it. If the Russian government headed by Vladimir Putin is of the view that it is a special operation, but what is the nature? What is the character? It is ultimately, and in ultimate analysis, you will find it is basically and fundamentally a war. Whether it has been launched by Russia or it has been what we call encountered by the Ukrainian people, it remains a war because we do not find any other result. And what happens in a war? Death and destruction, devastation of the infrastructure, decimation of the logistics, civilian targets have been what we call, the civilian people have also been targeted. Civilian targets have not been spared. And that is the, violations of the 4 Geneva Conventions. We have been witnessing, I do not find any kind of efficacy of the 4 Geneva Conventions of 1941, where it has been what we call, stated, and Article 3 that is common to all the 4 Geneva Conventions, and that has also attained the character of the customary international law. We find very flagrant violation of this particular article. 2 additional protocols of the 1977 have been significantly violated. Whether it was the Vietnam War, the Korean War, the Gulf War I, Gulf War II, or any kind of a war, what we have been witnessing, that only or merely the lip service has been done by the varying factions or the people in hostilities. They have been talking and paying some kind of a lip service. All kinds of booby traps, all kinds of what you call prohibited weaponry, all kinds of incendiary weapons are in use. The new inventions in the warfare are being tested. This is what we have, witnessed in the Gulf War I and Gulf War II, and now we are witnessing the Ukrainian war. I'm not talking of other, armed conflicts of the non-international characters which are still going on in many of the geopolitical entities. But on a global level, my dear friends, in the month of, September in 2006, in 2016, the United Nations General Assembly ultimately realized the political characteristics and how to what you call, address in a non-binding fashion, how to involve the entire humanity, entire membership of the United Nations organizations in General Assembly, and ultimately New York Declaration on Refugees and Migrants was adopted. And this is a very, very landmark declaration. And I must say that it is a political declaration. And it resulted, my dear friends, two global compacts, which have ultimately been adopted in 2018 for refugees and for other what we call migrants. Therefore, New York Declaration, my dear friends, sets out a comprehensive refugee response framework, which I have already talked of, and this CRRF, my dear friends, is setting out specific actions needed to ensure pressure on host what we call countries. And today, my dear friends, as many as more than 185 nation states have become the part of the global compacts because of its what we call non-binding character. That is the remarkable, because the idea of sovereignty, the idea of permanent fixation of responsibility or permanent imposition of any kind of an international treaty obligation, these are some of the features where we find that the national governments are reluctant. National governments are not ready to accept any kind of permanent or binding obligation as a part of their international responsibility. Whatever may be the Law Commission or International Law Commission, ILC's what you call draft articles on responsibility to protect. Whatever may be the the draft articles, particularly for the responsibility of the international wrongful acts. Whatever may be other important dimensions of the responsibility to protect, national governments are reluctant to adopt or to what you call owe any kind of responsibility. And therefore, my dear friends, the soft law is going to have a better result in the contemporary circumstances, particularly in an era of multipolarity. So that is the most important what we call dimensions, because that is going to what we call enhance, I should say, refugee self-reliance. It is going to expand, my dear friends, extract to third country solutions, and it is going to what we call improve upon conditions in countries of origin to enable refugees to return in safety and dignity. And based on these what we call fundamental objectives of the December 17 December or 18 December 2018, my dear friends, the United Nations General Assembly affirmed the global compacts on refugees. Another important dimensions, my dear friends, apart from these global compacts, in the context of what we call of European Union, the main funding, the funding available for asylum policies, because nothing moves in this world without money, and we require, my dear friends, some kind of a funding arrangements in this connection. And therefore, the main funding instrument in the European Union budget in the area of asylum is the Asylum, Migration and Integration Fund, that is known as AMIF. AMIF allocation during the what we call previous long-term EU budget, and that what we call demarcated and complemented of a what we call for a period of 6 or 7 years, that is started from 2014, I think, and goes up to what we call 2020, which what we call coincided with the migration crisis, was increased, my dear friends, from 3.31 what we call billion euros to 6.6 billion euros. For the current long-term EU budget, for what we call, and that starts from 2021 and goes up to what we call 2027 period, my dear friends, funding has been increased again under the AMI to euros 9.9 billion. including what we call in order to manage migration, asylum, and integration in an effective and pragmatic and humane way, including financial support to the member states or member nation states for solidarity, particularly that has been witnessed through resettlement and relocation. My dear friends, other European Union funding instruments and funding regimes such as the European Social Fund, the Fund for European Aid to the Most Deprived, and the European Regional Development Fund also allocate funds for the refugee rights, for the restoration, for the preservation, and for the implementation of the European asylum policies that has also, funds, and particularly it is allotted to these kinds of for the implementation of these kinds of policies, and it is not at all accounted for separately in the budget lines, and that is also not very clear, but some other what you call agencies have also been funding. Similarly, my dear friends, the initial 2014 up to 2020 allocation to what we call European Asylum Support Office, and that was subsequently branded as the EUA, was increased from 109 million euros to what we call 456 million euros in order to be, my dear friends, ready to provide full operational support for functionalization for the support for asylum procedures in the future. The new multilateral or multi-annual, I should say, financial framework was also contemplated, and that provides for a budget of 1.22 or 1.22 million euros, particularly the period that has been, it is not million, my dear friends, let me recall it. It is 1.20 or 22 billion what we call euros for a particular period that starts from that has already started from last year up to what we call that is 2021 to 2027. This is the period. And my dear friends, outside this multi-annual financial framework, we also having some other important what we call budgetary allocations for external measures, and that budgetary measures must also be taken into considerations, and that is EU Emergency Trust Fund for Africa, that is EU Regional Trust Fund, that is also what we call there, and these kinds of mechanisms have ultimately resulted in the implementation of the asylum policies in the context of Europe. Finally, if you take into account, my dear friends, previously outside the EU budget, the European Development Fund has been integrated into this particular fund, and that is popularly known as MFF, and that it starts from 2021 and goes up to 27. The heading neighborhood and the what you call world, it focuses on poverty eradication and achieving the 2030 agenda for sustainable development goals, but has increasingly been used to finance the response to migration issues in recent years. So this has been the entire what we call journey when we are taking into considerations this kind of understandings, and it is becomes what we call very, very important to understand, my dear friends. This entire framework, particularly the pact on migration and asylum, that has been what we call adopted by or with the spirit of what we call of solutions through new legislative proposals and amendments to the pending what we call proposals to put in place a system that is both human and effective, representing an important step forward in the way so far the European Union management of the refugee rights as well as the management of the migration that is taking place from what we call inwards and from what we call outside the Europe, particularly emanating from Syria and other what we call disturbed nation states, and they are finding greener pastures, greener what we call the viable human rights oriented integration and resettlement in some of the European nation states, and this is how this entire mechanism has been what we call functioning. And it becomes very, very important, my dear friends, to understand these dimensions. Therefore, it is incumbent upon to all of us to understand what exactly has been the understanding on this particular point. that has to be taken into consideration, particularly in the part of non-European nation states. Any questions? Any observations? Yes, please. Yeah, Mr. Ashok. Yeah, Mr. Huck.
In the current issue of the Ukraine-Russia conflict, if there any crime war really happened, then how tough it will be to prosecute Russia or the Vladimir Putin into the ICC, because the ICC also committed to the world community to ensure justice, especially in case of the war crimes.
My dear friend, we cannot contemplate ICC prosecution. If at all, one of the parties is approaching to ICC, then we must bear in mind, my dear friends, with due respect to the Rome Statute of 1998, International Criminal Court, as of now, or ever since the inception and establishment of the International Criminal Court, what we have been witnessing is the credibility of this particular judicial forum. International Criminal Court has been suffering from a crisis which I call as a credibility crisis. Because majority of the nation states are not a party to the Rome Statute of 1998. The very states who have been talking in terms of the protection of human rights, protection of the refugee rights, protection against what we call war crimes, crimes against humanity, crime of rape, crime of genocide, and other important violations of international human rights conventions, international humanitarian law conventions, and the convention, the statute of the 1998, have adopted some kind of a cynical approach. Therefore, in such a situation, my dear friends, International Criminal Court, if you see, it has been reduced as, not international, rather African Criminal Court. You will find the cases against the rulers, heads of states, heads of governments from the Africa continent. This particular international entity as a judicial forum of a criminal, what we call nature, has been flooded with. Moreover, we cannot contemplate any kind of a trial on lines what we have witnessed in the past. If you take into account of the criminal trials in the history of what we call of international war crimes or tribunals, we cannot replicate Nuremberg trial or the Tokyo trial or other important war crimes tribunals on Yugoslavia, on Rwanda, or other nation states. We cannot contemplate what Bangladesh constituted and contemplated in the form of the International War Crimes Tribunal to try the culprits of the War of Liberation of 1971, and many of the people of that particular time have been sentenced to death under parliamentary authorization or parliamentary what we call induced legislation that has established this particular piece of legislation in Bangladesh. We cannot witness any kind of such initiatives what we have witnessed in the recent history, in particularly in South Africa, in Nepal, in Sri Lanka, which is popularly known as the National Commission for Reconciliation and Truth. in the form of, or in the name of, transitional justice. So we cannot contemplate these kinds of what we call, instances in the situation between, Russian Federation and Ukraine. Because the Russian Federation is not any African nation state. Though the war crimes have been, committed, violations on a massive scale, the violations of human rights have, taken place. It is being still violated. All kinds of violations we have been, witnessing of the 4 Geneva Conventions of 1949 with its additional protocol of 1977. Women are not being spared. Children are not being spared by the Russian armed forces. All kinds of, violations of human rights. Civilian populations have been targeted or are being, targeted. Even to some extent, even the military objects have not been what we call, spared. Though that may be in certain, situations lawful, but it is a unilateral imposition of war upon, Ukraine. So we cannot contemplate, or the West would be in a position, I do not feel that the West would be in a position to prosecute Vladimir Putin or the, perpetrators of this kind of a, war that is going on between Ukraine and Russian Federation. So it is a violation of the entire what we call, international law. Despite the fact, lot of what we call promises, lot of, sanctions are being imposed upon Russian Federation, but in the long run, Russian Federation is not going to be what we call, decimated by this much of amount of, sanctions. But if you take into account, my dear friends, ever since the, Dublin Convention entered into force in 1997, asylum seekers have been given a common status in entire what we call, European Union. If an asylum application is rejected in one country, the person's right to apply for asylum in other European nation, countries is also revoked. For this, system to be just, all participating, countries would need to have common procedures for their handling of the asylum applications. And this is what, in the context of the European, member states, European Union member states have been doing in the context of the Ukrainian refugees. In the context of the Ukrainian refugees, they are being what we call, granted, upon their arrival, they are being what we call, granted asylum of a temporary character. So this is very, very important, my dear friends. In my, understanding, I may be wrong at this moment, but this is my understanding that we can, tame countries like what we call, Russia under international law. Whatever may be the amount of, sanctions, whatever may be the nature of, sanctions, whatever may be the, nature and characters of what we call of the international blockade or any kind of a, international embargo, but we cannot tame the countries like the Russian Federation in the long run. Because Russia can also, invoke and impose some, sanctions against its, counterparts. Today, Western, countries are coming out openly, and for the first time in the last, 70 years, we have witnessed a statement that emanated from the mouth of the President of United States of America, Joe Biden, and today he is making this kind of a statement that Rohingya refugees from Myanmar is the most persecuted community of, refugees. Earlier, they were, silent. What Russia is doing in, Ukraine, or earlier it has done in 2014 in Crimea, or other what we call, nation states, and now it has also further fragmented the political, integrity of, Ukraine into 3 autonomous, regions. United States of America has already done, and it has been, creating new organizations. It has been a new organizations who believes in violence, particularly it is generally, alleged without any responsibility. So far, the, public domain reporting is, concerned, and whatever the reports are there in public domain, it is generally alleged that ISIS was the creation of United States of America. He simply, wanted to unseat President Bashar al-Assad of, Syria. So in this kind of a situation, you can contemplate what has been done by United States of America in Iraq, in the Gulf War I and Gulf War II, what he has done recently in the past, what he call in Vietnam, or what kind of a military engagement it has generally sponsored in many other nation states, including Islamic Republic of Afghanistan, and how it has been what he call shirked his international responsibility and abandoned what he call Afghanistan in the most ugly manner, without any kind of having recourse to the international treaty obligations or international human rights treaty obligations. Simply it has what he call abandoned without specifying to what extent it has been successful in achieving its what he call geopolitical or military objectives in Afghanistan. So we failed to understand the similar. If we cannot prosecute any of the actions of the United Nations or the United States of America, then how it is possible that the international community would be in a position to prosecute any of the actions of the Russian Federation? So that is my submission. I'm not talking of the legal provisions, because the legal provisions, my dear friends, have become subservient. Though there are international legal frameworks, international what you call legal provisions, but who is going to implement them? So that is my what you call submission. Any other observation or any further question, Mr. Haq?
Sir, I personally believe that there is no true democracy in Russia, and the Russia government is not liable, and there is no
democracy, by the way.
There is no accountability there.
No, where is democracy, my dear friends? Where is democracy?
Sir, last 20 years, the Vladimir Putin is in the regime of Russian government. No elections, no other opposite party.
My dear friend, democracy is the most expensive luxury which no nation state can afford. Because the democracy does not stop by saying democracy. We require the democracy of interactions. We require the democracy of political remedies. We require democracy of demonstration. We require a democracy of freedom of speech and expression. We require a democracy of pluralism. We require democracy of multiculturalism. We require democracy of diversity. We require democracy of an intellectual character. I must have the democracy to pinpoint your faults. You must have the democracy to pinpoint my faults, my dirty face, my lacuna, or you must be in a position to air your disagreements. The democracy of disagreements. Where are these kinds of facets of democracy in any geopolitical entity? Today we are having the democracy, and we are affording this democracy to remain politically correct. We must appreciate the government of the day in any geopolitical entity, then we are very democratic. We should not voice any kind of opposition. We should not air any kind of dissension. We should not believe in any kind of opposition. Then we are very democratic. This is the universal truth now, and it has become the global trend. Even the fair criticism of the judgments delivered by the highest judicial establishment in many geopolitical entities are not considered a fair democracy. No institution, no political cult, no democratic institution is ready to brook any kind of what we call disagreement. Today, the decisions in many of the geopolitical entities, or majority of the geopolitical entities at international level, are taken under the garb of what we call democracy and against what we call democracy. That has become the hallmark, and it has become the pattern, fashion, trend, whatever you may call it. Decisions are taken on the basis of what you call the personal fiefdom and personal whims and magrams. And it is branded as democracy. So you have to be very politically correct. I am sorry. My last, 2 minutes observations are not in line with the, well-established norms. But as a student of what you call of, higher education, as a student of international refugee law, as a student while discussing the problems of, refugees, this is something which is attributable in the context of refugees or to entire, community of refugees. Because the basic idea or the basic dream and the most fundamental dream which I am espousing is that I want to see a refugee-free world. And at least during my lifetime, it is not going to be achieved. This I know. Even I can make some kind of prognosis at this stage on the basis of my studies that the refugee or the refugees are going to be coterminous with the life of this beautiful planet. As long as this planet Earth exists, refugee would always be there. Refugee they are also going to be there. So you can very well understand, my dear friends, how institutions have been functioning, how democratic institutions have been responding, what kind of a response is being contemplated. We have been witnessing, whether it is the Ukrainian refugees, whether it is the Rohingya refugees, what we have been witnessing, my dear friends, in the context of South Asia and in the context of Europe, we have been witnessing hate, racism, ethnicity, religion, political opinion, membership of a particular social group. These elements are deciding the fate of refugees. Yes, Mr. Shayan, you have also what is your opinion on the discriminative treatment of EU against refugees from Ukraine and the global south, especially Afghans and Syrians? They welcomed Ukrainians with open arms, but not those who escaped from other war-torn area. Is there a matter of racism and xenophobia? Yes, of course, you are absolutely correct. Mr. Shafiq Shayan, you have also answered this question. What we have been witnessing in the current situations in many of the European nation states, my dear friend, it is important to understand that in an atmosphere of racism, in an atmosphere that is surrounded and encapsulated by xenophobia, what we have been witnessing a discriminatory treatment against refugees. Even in South Asia, in each and every nation state of South Asia, what we have been witnessing that different treatments for different refugees are being meted out by the national governments. In India, Government of India, since charity begins at home, my dear friends, Government of India is having a multiplicity of treatments towards refugees. You will discern what kind of a treatment is there for Afghan refugees, for Tamil refugees, for Tibetan refugees, for Bhutani refugees, for Rohingya refugees, for Syrian refugees, for Rwandan refugees, for what you call African refugees, for what you call Pakistani refugees. I mean from Qadianis from Pakistan, and Hazaras from what you call Afghanistan, from Sikh refugees from Afghanistan. What kind of a treatment is there? You will find a classification of treatment which is exclusively based on discrimination. What kind of a treatment the government of Pakistan is meting out to Shias, Ahmadiyyas, Hazaras, Uzbeks, and the refugees from Central Asia, and what kind of a treatment the government of Pakistan is meting out to Afghan refugees. If you take into account the government of India's treatment of Afghan refugees, generally Afghan refugees are getting a better what we call deal from the government of India instead of the Rohingya refugees. Tibetan refugees are having the most what we call significantly their rights as refugees are being fulfilled by the government of India. Tamil refugees, because of the political what we call expediency, they are getting a better deal so far among all, refugees. Even in Bangladesh, what kind of a, treatment the government of Bangladesh is meting out? Despite the fact it is a very, very fast, growing economy. Per capita income of the Bangladeshis are far ahead if it is, compared with that of even Indians and Pakistanis in the current what you call, context. You can very well understand the growth which the government of, Bangladesh is achieving. That is highly appreciable. And there are, what you call, indicators. There are, facts and figures in the public domain. That is also, deciding, my dear friends, how these, national governments are treating foreigners, particularly refugees. Germany is having a different kind of a treatment. But at the same time, my dear friend, if you compare the treatment which generally Germany metes out to refugees, if you compare this treatment of Germany towards refugees with that of what you call of its counterpart again in Europe, and that is Spain, you will find a very discouraging picture. We have been, witnessing the emergence of the far right, what you call, nationalism in Australia, in what you call, Austria, in, Spain, and other, nation states, including what you call, I'm talking of the majority of the European nation states. So we find racism. And that is, dictating the fate of, refugees in these, geopolitical entities. Despite the fact the European nation states, European member states have been strengthening, my dear friend, have been strengthening this common European asylum system, even then, my dear friends, their unwritten policies, non-state actors, European minority groups, ethnic minority groups, who claims themselves as the natives of various geopolitical entities in Europe, they are basically opposing the arrival of, refugees. So this is very, very important, my dear. But at the same time, we should not forget, my dear friends, that in order to solve the refugee problems, the European Union has implemented numerous what we call, directives and measures, including to harmonize European asylum procedures over the last decades. However, if you take into account the previous studies, my dear friends, have found these efforts to be futile, with the differences remaining largely the same, or even what we call, these differences keep on increasing. And what you have, pointed out in case of, Ukrainian refugees, we have been witnessing the discriminatory policies. Even we have also witnessed in the recent exodus of refugees from Ukraine and their influx in the European Union nation states, of the European nation states, particularly in Moldova, in Poland, in Hungary, and in Slovakia and other what you call neighboring jurisdictions of Europe. We find the racist approach has always been there. Even the blacks, Asians have been pushed back, and the preference has been given to the white people, European what we call natives, the European people, at the cost of what we call of equality, at the cost of rule of law, at the cost of what we call of international law, at the cost of idea of human rights, pluralism, and collectively speaking, cumulatively speaking, at the cost of European values. So thank you very much. If you have more what we call comments and observations, most welcome. I will begin tomorrow with a new engagement, and we will be proceeding further. So thank you very much for the day. If you have other observations, you are most welcome. Any other question? And thank you very much, Mr. Shayan and Mr. Haq, for your observations. Yes, how are you, Mr. Ashok Bala?
Yes, sir. I'm doing well, sir.
Yeah.
Sir,
So how is everything at home?
Yeah, sir. My mother was sick, so she had a stroke. That's why I went to Bangladesh. I mailed
Yeah,
you.
I understand, and I'm sorry. I pay my good wishes for her early recovery, speedy recovery.
Yeah, she's now
I
fine,
pay
sir.
my salam to her. Yeah. Thank you very much. Yeah, enjoy yourself. See you tomorrow. Thanks a lot. Bye bye. Take care.
Thank you, sir.
Thank you, sir.
Thank you, brother. Thanks a lot.